Hello everybody, it's Zach here from RealEstateLicenseWizard.com. Today is the day a lot of you guys have been looking forward to, me included. Today I'm going to go over 100 questions from our National Real Estate Practice Exam. Now this will be our 2021 version, and if you watched our previous 2020 or 2019 videos, you'll already be familiar with the format. Now if you haven't watched those videos, I highly suggest you do. While the versions are different, the information on those videos are still relevant and still a fantastic study resource. Now this version will have some newer questions mixed in, and I'm so excited to go over the materials with you guys. Now we will probably add a new version every year, so if you're watching this in the distant future, look for that too. Now the way this works is I go through every question, we read it over together, and give you guys an opportunity to think about the question, and then we come up with the answer and discuss it. I highly encourage you guys to grab a paper and pencil and follow along that way. That way it's just like taking a real exam and you could have a simulated test experience. Now if you guys want to take the real deal, head over to our website, RealEstateLicenseWizard.com. There we have this practice exam as well as our prep course, flashcards, and more. Now lastly, of course, since this is such a great resource for everyone studying for the exam, we ask that you like this video and subscribe to the channel if you're new here. That way you can be fully prepared come exam day. Anyways guys, buckle up, grab some popcorn, grab your paper and pencil, and let's get started. Alright, so question 1, our first question. Which of the following laws prohibit discrimination in the buying, selling, renting, or financing of housing? These laws prohibit discrimination based on race, religion, color, sex, disability, children, nationality, and more. And it gives us 4 options. A, the Fair Housing Act. B, the Equal Credit Opportunity Act. C, the Civil Rights Acts of 1866 and 1964, or D, the Smart Opportunity and Housing Act. So like always, now is the time I'm going to give you guys an opportunity to pause, read it over. I'm going to give you guys some time in the video, of course, for those audio listeners. Think over the question and come up with your answer. So do that right now. Alright, so did you guys come up with your answer? Hopefully. This one's a pretty straightforward one. The correct answer for this one is A. It is the Fair Housing Act. So the Fair Housing Act is the law that prohibits discrimination in the buying, selling, renting, or financing of housing. These laws prohibit discrimination based on race, religion, color, sex, disability, children, nationality, and more. It's super important to understand fair housing laws for the exam, so hopefully you guys got this one. Alrighty. Let's see, next question, question number 2. Okay, used in connection with CERCLA and the creation of the Superfund, retroactive liability means what? And it gives us 4 options here. So A, all previous owners are not held accountable for the hazardous waste site. B, all previous owners can be held accountable for the hazardous waste site. C, the last 2 previous owners also can be held accountable for the hazardous waste site. Or D, the last 3 previous owners also can be held accountable for the hazardous waste site. So I'm going to give you guys an opportunity to think this one over and come up with your answer starting now. Alright, so hopefully you guys came up with your answer on this one, and obviously I hope it's the correct one. So what is the correct answer for this one? Well, it's going to be B. That's right, it's all previous owners. Again, that's all previous owners. So the term retroactive liability is used in connection with CERCLA and the Superfund, obviously, and it means that all previous owners can be held accountable for the hazardous waste site. Super important to understand when we're talking about environmental real estate and the laws associated with that you are familiar with the term retroactive liability. All right, next question. Question 3. So, when you buy real property, you gain several different kinds of rights, one of which are called surface rights. What are surface rights? And it gives us 4 options. Is it A, the rights to the natural resources lying below the Earth's surface? B, the rights to use the surface of the Earth? C, the rights to use any rock, soil, or hard object? Or D, the rights to the trees, ferns, and other plants? So like always, here's an opportunity for you guys to think of the answer, come up with it starting now. All right, so hopefully you guys came up with your answer on this one. This one's another pretty straightforward one. When we're talking about surface rights, we're talking about the surface of the Earth. So that would be the rights to use the surface of the Earth. So our correct answer is B. But yeah, so subsurface rights we're going to discuss. Well, maybe we will, depending on how this exam pans out. But obviously, subsurface rights, those are those natural resources lying below the Earth's surface. Surface rights are the ones above. Interestingly, and this is a key takeaway, an owner can transfer rights without transferring the subsurface rights. So they can transfer certain rights, whether it be the subsurface or the surface, without transferring vice versa. So for example, a landowner, they can sell their rights to an oil and gas company for his land. So those would be his subsurface rights, but he can still own the surface rights, which has the land on it itself. So maybe his property, his home, stuff like that. Hopefully that makes sense. But yeah, be familiar with those two terms. And yeah. All right. So next one, question number 4. All right, so a collection of federal and state government laws that regulate the conduct and organization of business corporations, normally to promote fair competition for the benefit of consumers. So it gives us 4 options here. Is it A, the civil rights and business laws, B, the business and ethics laws, C, the civil rights laws, or D, the antitrust laws? So like always, here's an opportunity for you guys to think about it, come up with your answer, and we'll meet up in a couple seconds. Alrighty, so hopefully you guys came up with your answer on this one. What is the correct answer? Well, it's going to be C. Or I'm sorry, not C. D. It is D, the antitrust laws. So the antitrust laws are a collection of federal and state government laws that regulate the conduct and organization of business corporations, normally to promote fair competition for the benefit of its consumers. Now, in retrospect, antitrust laws protect the consumer and are healthy for a stable economy. Now, it's important to know and understand the ones that deal with real estate agents because they obviously directly affect how you are going to function as an agent when you pass your exam, things like that. Don't get these mixed up with the civil rights laws or any other ethics laws. Again, when we're talking about antitrust, it's specifically the ones that regulate the conduct in the organization of business corporations to promote fair competition. And again, this is all for the benefit of the consumer. Yep. Alrighty. Next one, number 5. All right. So number 5 is the lender in a traditional mortgage loan transaction is known as the what? And it gives us 4 options. A mortgagee, B, mortgagor, C, a trustor, or D, a trustee. So like always, I'm going to give you guys an opportunity here to come up with your answer starting now. Alrighty, hopefully you guys came up with your answer on this one. Don't forget too, if you guys do ever need more extra time, because I do get comments about this all the time, like, oh, maybe you didn't give enough time, or maybe, I'm giving too much time or things like that, remember you can pause these YouTube videos with the space bar, or if you wanted to turn on the speed, feel free to. I don't mind at all. This is for you guys to study. So some people like the extra spaces, some people don't, things like that. So just keep that in mind as you guys are studying. This is here for you guys, so feel free to use it however you want. All right, so what is our answer for question 5? It's going to be A. That's right. It's a mortgagee. So a mortgagee is the entity that that lends, I almost said leads, that lends the mortgagor money. This entity is typically referred to as the lender. So yeah, when you see this term, they like to throw these EEs, OR rules. I'm sure you guys have heard about that before. They like to throw these on the exam just to really confuse you guys. But truth be told, it is important. It might be like confusing. You might think, oh, why are they like complicating things when it's so super simple? But truth be told, you guys will see these terms on contracts, and that's why it's important to understand, because when you get your license, you're going to be handed a bunch of these contracts, and you're going to have to look through them sometimes, and you're going to have to be familiar with these terms. So that's really why they grill you on these terms so much, is when it comes to contracts, because again, your job as an agent is to help with these contracts, kind of facilitate these transactions, and you're going to be using your best tool at hand, which is a contract. So be familiar with these terms. All right, next one, question 6. If a contract has prepayment penalties, they can be found in which real estate contract clause? Is it A, in the habendum clause, B, in the defeasance clause, C, in the prepayment penalty clause, or D, in the penalty and insurance clause? So as always, here's an opportunity for you guys to think this one over. Give you guys some time to come up with your answer. Alrighty, so hopefully you guys came up with your answer on this one. What is the correct answer? Well, it's going to be C, of course, in the prepayment penalty clause. So don't be not confident with these questions. Sometimes they're pretty straightforward like this. If it says prepayment penalty, chances are, it's the prepayment penalty clause. Don't overthink this at all. But yeah, the prepayment penalty clause states that a lender can penalize a borrower if the borrower pays off the mortgage much sooner than usual. Lenders are required to disclose prepayment penalties at closing in the form of a prepayment penalty clause. Now, it's worth noting with these prepayment penalty clauses, it's such a tongue twister. Woo! It's worth noting with these that they're becoming more and more less common, because to be quite honest, it is a little bit ridiculous. I mean, if you're paying off your mortgage early, or you're paying off your loan early, why should you get penalized for it? In the opposite, the lenders would say, well, we do run a business here, and we have to make money. So that's how they get their extra fee if someone pays it off super quickly. So there's some really interesting ethical discussions about that, but that's not really why we're here for this video today. But again, it is important to kind of understand, not just for the exam, but for when you guys get out there and work with your clients. You should be familiar kind of with these terms, and also these opinions, and how they roll out in the real world. Because let's be honest, that's why we're here. We're here to get your license so that you can be an agent and you can help people and make money. So yeah. All right, next one. Question 7. Fees that the buyer pays to close the deal are called, and there's 4 options like usual: A, seller's cost, B, closing costs, C, broker fees, or D, earnest deposits. So like always, here's an opportunity for you guys to come up with your answer on this one. All right, so what's the correct answer for this one? It's going to be B. That's right, it's your closing costs. Don't be confused with this one, guys. Again, this is one of those ones where it's pretty straightforward. You just have to know your terms and be confident and choose the correct answer. So closing cost is our answer. Closing is the final step in executing a real estate transaction. It is when ownership and payment is transferred to the rightful parties. Now, the fees that the buyer pays to close the deal are called closing costs. It's as simple as that. Alrighty, next one. All right, 8. Which of the following best describes eminent domain? Ooh, fun one. I love talking about this stuff. All right, so choose one of the answers, obviously. And we have four options. So there's A, a term used to describe the right of the government to take privately owned livestock. B, a term used to describe the right of the government to take over privately owned real estate. C, a term used to describe the right of government to take over privately owned bank accounts. Or D, a term used to describe the right of government to take over people's children and sometimes pets. So, like always, here's an opportunity for you guys to read it over again, think about it, all that good stuff, and come up with your answer. Alrighty, so what is our answer for this one, guys? What is it? It is B. That's right. It is the term used to describe the right of the government to take over privately owned real estate. That's super important to know. So, eminent domain is a term used to describe the right of the government to take over privately owned real estate, usually despite the owner's wishes, which is a little asterisk on that. So, this often happens for land that is required for infrastructure. Think things like highways, pipelines, railroads, things like that. Now, the Fifth and the 14th Amendments of the U.S. Constitution permit the government to exercise its power of eminent domain. That's a little bonus snippet. They usually don't ask specifically about, which amendments, but, that is kind of important to know. So again, yeah, eminent domain is just the term to describe the right of the government to take over privately owned real estate. And again, it's usually despite the owner's wishes. Alrighty, next one. Which of the following legal concepts requires real estate listings to be in writing? And there's four options. Is it A, the Fraud Enforcement and Recovery Act, B, the Fair Housing Act, C, the Statute of Transgression, or D, the Statute of Frauds? So, like always, here's some time for you guys to come up with your answer. Alrighty, so hopefully you guys came up with your answer on this one. What is our correct answer? It's going to be D. It's the Statute of Frauds. So, the Statute of Frauds requires certain types of contracts to be executed in writing. The Statute of the Statute of Frauds covers contracts for the sale of land, agreements involving goods worth over $500, and contracts lasting 1 year or more. So, you'll be familiar with this term if you're not already. This comes up all the time, not just in real estate, but in other forms of law. The Statute of Frauds is really important because it's one of those laws and statutes that really builds a fair foundation for how business and agreements should operate. And when I'm talking about agreements, I'm talking about contracts, whether it be a unilateral contract or any type of contract. That's kind of what they did with this. They wanted to make it as fair and as easy as possible for, again, when we're like circle back from earlier, we're talking about consumers here. So we want to protect consumers. And that's pretty much, a contract in writing is the safest bet. We don't want those verbal contracts. We want those, if it's going to be for the sale of real estate, something that's so expensive and so important for people, we want that to be in writing. And again, that comes back to the Statute of Frauds. Alrighty, next one, question number 10. All right, we're already 10 down. All right, so the compliance with zoning ordinances is monitored through the insurance of what? And it gives us four options. Is it A, buffer zones, B, CCRs, C, covenants, or D, zoning permits? So like usual, here's some time for you guys to read it over, come up with your answer, and figure it out. Alrighty, hopefully you guys came up with the answer on this one. So what is our answer? It's going to be D. It is zoning permits. So compliance with zoning ordinances is monitored through the insurance of zoning permits, where the property owner or developer cannot substantially alter the use of the property without getting a zoning permit, which will not be issued unless the proposed development conforms to the zoning ordinance. Zoning permits are usually required before building permits can be issued. So guys, this is super important to understand, especially when you're dealing with local government or even, big cities where there's a lot of zoning rules and laws and things like that. The only way that things can be organized and can be, safely built in a city is if there's some sort of set of ordinances or rules. And in order to, accept those rules and to make sure that people are potentially following them, they have to ensure the zoning permits. So that is basically when, let's say maybe you want to build a deck on the back of your house or some sort of, second apartment building or something crazy. You need to go to your local government. You have to get a zoning permit to make sure that, you are following those zoning ordinances. So yeah, it's basically that. It's pretty straightforward, so just be familiar with that for the exam. All right, question 11. A double net lease is a rental agreement where, and it gives us four options. Is it A, two tenants will split the rent, B, yearly taxes are doubled but rent is cheaper, C, two additional costs will be added to your base rent, or D, three or more additional costs will be added to your base rent? So like always, here's an opportunity for you guys to come up with your answer. Alrighty, so what is our correct answer for this one? It is C. That's right, it's C. It is two additional costs will be added to your base rent. So this is another one of those. I think we've had two of these questions already before where you shouldn't overthink these. When you read that definition and when you read the word, or maybe not even the word but the term, or maybe just the sentence, don't overthink these. Normally, a lot of these questions, they will have the answer right in front of you. You just have to stay confident and stay true to yourself and understand, okay, I know this. I got this. And have faith that you know what you're talking about. And that's another one of these ones. I mean, seriously, guys, double net lease. Two additional costs, double meaning two. It's as simple and straightforward as that. So a double net lease is when two additional costs will be added to your base rent. Usually these things are taxes and insurance costs, but that part you really don't need to be familiar with as much. Just be familiar with that. Again, the double net is meaning the two additional costs will be added to the base rent. Alrighty, next one, question 12. Which of the following best describes the term emblements? Ooh, this is a fun one. Okay, so there's four options. A, use of a property in any legal manner. B, a use of the property in any means deemed legal. C, a thing used to make property look more attractive. Or D, annual crops produced by cultivation legally belonging to the tenant. So like always, here's a quick opportunity for you guys to read it over and come up with your answer starting now. Alrighty, so hopefully you guys came up with your answer on this one. What is our answer? It's going to be D. It's annual crops produced by cultivation legally belonging to the tenant. So, fun little story about this one. When I was studying, when I was in your guys' seat, as you are right now, I was looking this up and I could not find. I found like one or two articles about it, and this was way back in the day. But and all the information was really conflicting. And I always part of the reason why we do this and we establish what we're doing here now is for that reason. Is because it was so hard to find information that was centralized because there's so much conflicting. You know how it is with the internet and not just the internet, but just a lot of information's out there. So it's hard to really refine it and make sure you're finding the right stuff. So implements are annual crops cultivated by a tenant that is treated as the tenant's personal property. So that's that last part that I couldn't figure out. It is the tenant's personal property. So when you think of personal property, we'll probably discuss this later on, but when you think of personal property, remember it's those physical things that you could pick up and grab and take with you. It's not real property. It's not things like the house itself. It's personal property, maybe the couch and things like that. For some reason, in the beginning, I couldn't grasp, crops being personal property because those are in the ground. But again, because it's the tenant, so again, the tenant grew these crops. That's technically their property. That's their personal property because, they deserve the right, and this is by law, they deserve the right to cultivate what is legally belonging to them. So that's how it works. But yeah, so a little side story about that one. Sorry if I get off track, but I just always find that a little interesting. But anyways, all right, question 13. So a buyer of a home was not informed that his house was on a septic tank system. The buyer has the right to, and there's 4 options. A, rescind the contract. B, sue the broker for his license. C, sue the title company for failure to discover the problem. Or D, nothing if the contract is signed. So, like always, here's some time for you guys to read it over, come up with your answer. Alrighty, so what's our answer for this one? It's going to be A. That's right, rescind the contract. So the important takeaway with this one is an agent must reveal all property facts and defects known at the point of sale. Failure to do this or just to disclose this information may allow the buyer to rescind the contract. That's super important. So I guess the bonus takeaway to this question is just make sure when you guys are out there, you are disclosing all the information that is necessary at the point of sale. Alrighty, next one. All right, 14. Real property can be converted to personal property by, and it gives us 4 options: inference, severance, accession, or deconversion. So let me repeat that one more time. I didn't do it without the letters. A, inference. B, severance. C, accession, or D, conversion. So come up with your answer on that one, and we'll reconvene in a couple moments. Alrighty, so what is the answer for this one? So, I love this question. This one's kind of a fun one for me. So I don't know. Let's do a mini game in our heads, okay? So maybe you guys have one option, but just in your mind, think of a second option, what you think it could be. And then, yeah, just keep that in the back of your head for when I explain this. So, what is our correct answer? It's going to be B, severance. Now, maybe it's just me, or maybe it's you guys too, but I don't know. Did you guys also think that maybe it was D, conversion? I don't know. I just kind of thought that as well until I really learned about severance and how, it's specifically the opposite of attachment. then I kind of understood. Oh, that makes sense. But for some weird reason, it's not just me too, because I've actually talked to some of our students about this. Our brains want to think it's conversion sometimes. I don't know. But anyways, it's severance. Don't think it's conversion, and maybe that'll be a good remember or a reminder for you guys. You'll be like, oh yeah, it can't be conversion. It can't, because we discussed that it specifically is not. It has to be severance. But yeah, so severance is the opposite of attachment, as I discussed earlier. And I think that that's a great way of remembering it, because obviously attachment is when personal property is converted to real property. So the opposite of that is severance. You're severing something. Again, severance is taking an item that is attached to the land and removing it as personal property. So be familiar with that and you'll be good to go come exam day. All right, next question. Question 15. All right, so an offer to purchase real estate becomes a contract when it is signed by and it gives us 4 options. Is it A, the seller, B, the buyer, C, the buyer and seller, or D, the seller and the agent? So like always, here's some time for you guys to think it over. Alrighty, so hopefully you guys came with your answer on this one. When in doubt, for the questions like this, choose the safest option. And what is the safest option? It's obviously going to be the buyer and the seller. Let's be real, guys. You're not going to have a contract that it's just one person, signing it, unless obviously, well, we don't need to get into that yet. But in these cases, remember we were talking about earlier when the statute of fraud and statute of limitations, things like that. Remember, this is all to protect the consumer. So it makes sense, right, that a buyer and a seller has to sign these paperwork or the paperwork. Imagine if someone came to your house and was just like, hey, I already signed this, the sale of the house is mine. I mean, that wouldn't work. That'd be ridiculous. It'd be crazy. So keep that in mind. Just when in doubt, I think this is just a good rule to follow for when we're discussing these questions, is when in doubt, choose the safest option. Choose what would make the most sense for a consumer, whether it be the buyer and the seller or both. So keep that in mind. Alrighty. Oh, here we go. Here's a little math problem. Uh-oh. All right. So question 16. Utilizing the 28 by 36 rule, if Rebecca's gross income is $4,500 a month, she would need to spend less than blank in housing costs a month to qualify for most loans. Is it A, $1,200? Is it B? Actually, I'll read it a little differently. I apologize for that. Is it A, $1,200? Is it B, $1,260? Is it C, $1,728? Or is it D, $13,500? So like usual, I'm going to give you guys some time. Actually, I'll give you guys some extra time on this one because it is a math problem to come up with your answer. So go ahead and do that right now. Alrighty, hopefully you guys had enough time on that one. If not, like I said before, feel free to pause. Don't be afraid to use these tools that YouTube or whatever browser you're watching this on has what provides for you. If you need to fast forward a little bit, that's fine too. No biggie there. So the 28 by 36 rule, how does that work? So the rule states a household should spend a maximum of 28% of its grossly monthly income on total housing expenses and no more than 36% on total debt service. So lenders typically want no more than 28% of your gross monthly income to go towards your housing expenses, including your mortgage payment, taxes, insurance. So once you add in monthly payments and other debt, the total shouldn't exceed that 36%. So that's kind of the rule and behind that, for those of you guys who weren't familiar with that. So now when we're talking about this problem, what is our answer? So our answer is going to be B, that $1,260. So how did we get that? Well, it's actually quite simple. All you do is multiply 0.28 to her monthly income. So in our case, you would take that number here, that $4,500, you would multiply by 0.28, and you would get that $1,260. So pretty self-explanatory. And actually, you know, if you're sitting there wondering too, maybe this is your first practice exam video that you've watched or something, and you're thinking, oh my God, is there math on the exam? Things like that. We do have a video covering that single question, is there math on the real estate exam? So check that out as well if you are wondering. Obviously, since a question showed up today, there's going to be some questions in most cases. But there are some states that don't have math questions, so keep that in mind as well. But anyways, enough about that. We did that. Let's move on to our next question. All right, question 17. When you borrow money to buy real estate, you give the lender a blank against the property. All right, and there's 4 options. It's A, tax lien, B, a mortgage lien, C, a judgment lien, or D, a deed. So like usual, here's an opportunity for you guys to pause and come up with your answer starting now. Alrighty, so what is our answer for this one? What is it going to be? Well, it is B. That's right, it's a mortgage lien. So when you borrow money to buy real estate, you give the lender a mortgage or a mortgage lien against the property. A mortgage lien is a voluntary, specific lien. In fact, it's the most common type of voluntary real estate lien, which makes sense, right? I mean, you hear that term all the time. Pretty straightforward one there. I won't explain too much else about that. All right, question 18. What is the biggest difference between private and public land use controls? Ooh, this is a fun one. All right, so there's 4 options. A, private land use controls are written in the Constitution, while public are up to the local governments. B, public land use controls are written in the Constitution, while private are up to the local governments. C, the government does not write or enforce private land use controls, but it does impose and enforce zoning. And then D, the government writes or enforces private land use controls, but it does not impose and enforce zoning. So like usual, I'm going to give you guys some time to think about this one and come up with your answer. So go ahead and do that now. All right, so what is the answer on this one? It's going to be C. That's right. The government does not write or enforce private land use controls. Obviously, it does impose and enforce zoning. So let's talk a little bit about that. So first, starters, when you hear these terms public and private, you should start to kind of understand the big picture here with what those means. So when we're talking about public, that normally means it's issued by the government or it's government related. So because it's a public land use control, which obviously that it would be zoning, that would be by the government. Now, when we're talking about private, that's private, think of like privately owned businesses, privately owned property, private. That is with deed restrictions or restrictive covenants, which limit, what those are, basically just limit what can be done on a property by the owner. But the biggest difference, of course, when, we're bringing things full circle, is that the government does not write or enforce private controls because it does not impose and enforce public controls like zoning. So let me explain, or I'm sorry, but it does. Let me explain that one more time. Sorry. It's a little bit of a tongue twister, all the, P's and public, private, all that good stuff. So let's make this super simple. Okay, let's not overthink this. When you think public land use control, think of zoning. Think zoning that is issued by the government. When you think of private land use controls, you need to think of privately owned property, privately owned businesses, things like that. Those are either deed restrictions or restrictive covenants. And that makes sense, right? Because those things in particular a government can't enforce. If you're an HOA, and this is always a good example. Let's say you're in the HOA and you write a private land use control. Let's just say it's a deed restriction, and you get together with your HOA members, and you guys all come up with these certain rules, and you have to write them into the deeds, okay? And maybe it's like, trees can't grow a certain height, or maybe you can't have more than 3 bushes, something like that, okay? The government's not going to come in and be like, hey, you can't do that. Or, if someone has more than a couple of bushes, they're not going to be like, hey, no, you can't do that. That's not the government's job. They've got way, way more important things to deal with, obviously. When it comes to zoning, they do interfere there, because zoning is for the public safety, or, that's what the public voted on these rules, or they voted on someone to make these rules, and that's where they get involved. Whereas the private, they do not get involved. They don't write the laws, one, as we discussed before. They're not in the HOA. They've got other things to do. And two, they don't enforce those controls, because, again, that's not their job. It's not the government's job to interfere with these little issues that maybe a deed might have, or something that an area, a restrictive covenant or something like that. Like, it's just not like that. And hopefully that makes sense. I apologize if I confused you guys. If I did, feel free to leave a comment and I can explain a little bit better. But for the sake of time, we do have to move on that one. But yeah, just to quickly recap in 5 seconds. The primary public land use control is zoning, and that's issued by the government. The primary private land use control is deed restrictions or restrictive covenants, which limit what can be done on a property by the owner. And again, the biggest difference is that the government does not write or enforce private controls, but it does impose and enforce public controls. Hopefully that makes sense. Alrighty, question 19. Earnest money should not be deposited into a trust account. Or, I'm sorry, should not. It says should. Number 19, earnest money should be deposited into a trust account, and it gives us 4 options. In a timely manner, A, in a timely manner according to state laws, B, after the removal of all contingencies, C, at the broker's or agent's discretion, or D, according to MLS rules. So like usual, here's an opportunity for you guys to come up with your answer. Alrighty, so hopefully you guys came up with your answer on this one. What is our correct answer? It is A. That's right, it's A. It's in a timely manner according to state laws. So this is one of those ones, it all depends. In your state, it might be 1 business day. In your state, it might be, 1 week or 1 business week, things like that. But yeah, it's the rule of thumb is it's in a timely manner, but again, it's according to state laws. So again, that varies from state to state, but it's best practice to always deposit the money as soon as possible. Alrighty, next one. Alright, 20. Alrighty, so Mrs. Jane lives in a small residential neighborhood. 100-year-old trees surround her home, and her neighbor, Mr. Joe, claims the trees are on his property and is planning to cut them down. Mrs. Jane tries to reason with Mr. Joe, but he refuses to listen. Mrs. Jane files a lawsuit that includes a court order for Mr. Joe to stop his actions until they can work something out. What type of court order is this? Wow. So this is a big question. Let's unpack that. Let me read the answers, and then we'll unpack that after. So there's 4 answers, or 4 potential answers. Is it A, a temporary protective order, B, an authorized dispute order, C, an injunction, or D, an easement? So let me scoot that up just a little bit more so you could read it all and come with your answer. So here's some time for you guys. Come with your answer, and then we will unpack this very shortly. Alrighty, so hopefully you guys came up with your answer on this one. What is our correct answer? Well, it's going to be C. It's an injunction. Oh my goodness, my cat just jumped on my chair. I apologize for that if that sounded loud. The correct answer is C. It's an injunction. All right, so let's unpack that for a bit. So if a dispute is pending, the court will likely issue an injunction preventing Mr. Joe from cutting down the trees until they entirely resolved. Injunctions can be used to protect interest in real property. A court-ordered injunction can be used to prevent a harmful action, stop ongoing or repeated conduct, or force a defendant to take action to prevent harm. So this is one of those legal terms that you need to be familiar with in case it does come up, and it's just pretty straightforward as that. Now, when you're looking at this problem, you might be wondering, wow, this is a lot. This is like a lot to unpack. When you are dissecting these problems, my advice for you guys is to just read the first sentence that sounds like it's important, and then the very last sentence that's the question. So for this one, I would read this here. So Mrs. Jane files a lawsuit that includes a court order for Mr. Joe to stop his actions until they can work something out. What type of court order is that? So really all this part is the most important part of that question. And knowing this, you can tell, okay, stop his actions and work something out. It's almost like a break. It's almost like a pause. That would be an injunction. Again, because we know this definition, right? We know that is used to prevent a harmful action or stop ongoing or repeat contact. So it is almost like a pause. So keep that in mind as well when you're dissecting these longer questions. Just look for the two, most important parts and then kind of take it from there. Alrighty, next question. Question 21. An agent took a listing and later discovered that her client had previously been declared incompetent by the court. The listing is now, and it gives us 4 options. A, unaffected because the agent was acting as good faith as the owner's agent. B, unaffected because her client took the listing, making it a verbal contract. C, of no value to the agent because the contract is void. Or D, renegotiable by both parties. All right, so here's an opportunity for you guys to pause that real fast, and I'm gonna go take care of my cat because she's going a little nuts and I don't want her to make noise, so I'll be right back. Alrighty, I am back. My cat is still having fun around my room, so disregard any cat toys in the background. I do apologize for that. I'll try and fix that. But it's just one of those days, like you guys wouldn't imagine. First of all, there was a storm that came out of nowhere, so I had to postpone my recording because, the thunder and stuff like that and lightning, all that crazy stuff. And then now my cat is just having a field day, and she's really living her best life to the fullest. So again, I apologize if you hear any squeaker toys or anything in the background. But anyways, enough of that. Enough distractions. Let's get down to business. So we've got this question here. It says an agent took a listing and later discovered that her client had previously been declared incompetent by the court. The listing is now what? So the answer for this one is C. It is of no value to the agent because the contract is void. And that makes sense, right? When we discuss our contracts, there's a couple different things that we have to remember. In order for a contract to be valid, the party must be 18 years old and of sound mind. That part is super important for our question, of sound mind. And then a contract obviously must be legal. So for example, there cannot be a contract to kill, steal, or anything illegal. And obviously the contract must hold a clear and definite consideration, which means there must be mutual consent of the contract since the client has been declared incompetent by the court. The listing is now void. So again, when you're reading these ones, just remember what you learned about contracts in your pre-licensing or maybe in school about how, what makes sense. I mean, it's one of those ones, if you really want to take a step back and look at the big picture here, what makes sense? you know that her client has been declared incompetent by court. How would that be fair if the contract would still remain? So now the contract is void and it is no value to the agent. Simple as that. All right, next one, question 22. So a real estate agent advertised a home for $250,000. When a Chinese couple asked the agent for the price of the house, the agent told them the seller wanted $260,000 instead. Under the Federal Fair Housing Act of 1968, such a statement is, and there's four options. A, legal because the Chinese family still has the opportunity to buy a house. B, legal because the representation was made by the agent, not directly owner. C, illegal because the terms of the potential sale were changed for the Chinese couple. Or D, illegal because the difference in the offering price and quoted price was greater than 10%. So here's some time for you guys to figure that one out, come with your answer and all that good stuff starting now. All right, so what's our correct answer for this one? It's going to be C. That's right, it's illegal because the terms of the potential sale were changed for the Chinese couple. So you might have thought maybe it's D because that says it's illegal, but and you know there was quoted 10% higher, but that does not matter, guys. It doesn't matter at all, in fact. All that matters is that the potential sale was changed for the Chinese couple. And again, that is the foundation of the Fair Housing Act, and we touched on that, I believe, a little bit briefly earlier. But again, the Fair Housing Act is the law that prohibits discrimination in the buying, selling, renting, or financing of housing. These laws prohibit discrimination based on race, religion, color, sex, disability, children, nationality, and more. So changing terms of the sale because someone is Chinese is clearly illegal and a violation of the Fair Housing Act. So don't overthink this one. Know your fair housing, and you should understand questions like this. All right, next one, 23. Oh, we're doing another fair housing question. All right, so under the federal fair housing law, which of the following is considered discriminatory advertising? So come up with your answer on this one, starting now. Alrighty, so hopefully you guys came up with your answer on this one. What is our correct answer? Well, it's going to be C. It is Catholics preferred. Okay, so why is this discriminatory advertising? Well, a couple things to unpack here. So first of all, saying seniors welcome, even though that might be ageist or, you know, well, not ageist, but it has to deal with someone's age. That isn't. They're just saying that's welcome. You could put a sign up that says anyone's welcome. That wouldn't make it, you know, discriminatory advertising. But when you say preferred, that implies, you know, something that maybe it's a little bit discriminatory. And again, when you learn about the federal fair housing laws, you kind of understand that there's certain language that you have to be very careful with. And this is one of those instances where you just have to understand Catholics preferred, not okay, because again, that is Catholicism is religion, and religion is protected under federal fair housing. So can't say that. All right, next one. All right, question 24. A mortgagor is also known as the, and it gives us four options. Is it A, the borrower, B, the lender, C, the finance specialist, or D, the mortgage broker? So like always, I'm going to give you guys an opportunity to pause here and come with your answer. Alrighty, so what is our correct answer for this one, guys? It's going to be A, the borrower. That's right, the borrower. So the borrower is a mortgager while the lender is the mortgagee. Remember we discussed that earlier? The mortgagee, or I don't know, did we discuss that? I think so. It's all blurring together. But yeah, so a mortgagor is the borrower while the lender is the mortgagee. A mortgagee is the entity that lends money to the borrower, also known as the mortgagor, for the purpose of purchasing real estate. So again, this is one of those questions where, don't overthink it. Just remember your vocab, just remember your vocabulary, and you know that borrower means mortgager. And remember, when you see these terms on the exam, the reason they do this, again, is just for the contracts. Because in your, when you become an agent, in your experience, you're going to see these terms often on contracts. So that's why they put these on there. That's why you need to be familiar with them and all that good stuff. All right, next one. All right, question 25, or a quarter of the way there. Keep up the great work, guys. All right, so 25. Which of the following fits the description? A mortgage loan available for military service members, veterans, and eligible surviving spouses, which often comes with better terms than a traditional mortgage. So is it A, VA loan, B, FHA loan, C, a military service loan, or D, an adjustable rate mortgage? So as always, come up with the answer. Here's some time for you guys to think it over. All right, so this one's pretty self-explanatory. You guys, I'm sure have heard of this. It is A. It is a VA loan. So a VA loan is a mortgage loan available for service members, veterans, eligible surviving spouses. They often come with better terms than a traditional mortgage, which is why they are commonly sought after. The program was established by the United States Department of Veterans Affairs and has been a strong success ever since. VA loans are only for active military service members, veterans, and certain military spouses. Aside from that, most military loans require moderate credit. Now, one of the biggest advantages of a VA loan is in some circumstances, people don't even need to have a down deposit for the property that they want. So they also come packaged with lower interest rates as well. So if you qualify for VA loans, they're the way to go. And obviously, in your everyone here's instance, if someone comes to you, and they qualify, you should definitely be like, hey, if you qualify, I would probably go for this, because 90% of the time, maybe even higher, VA loans are the way to go. If they qualify, go for it. All right, next one, 26. Under these rights, all landowners whose properties adjoin a river or stream have the right to make reasonable use of it as it flows through or over their properties. Is it A, river rights, B, ad valorem rights, C, littoral rights, or D, riparian rights? So as always, here's some time for you guys to read it over, come up with your answer starting now. Alrighty, so this is a age-old fun question. You guys have probably seen this one before when we are talking about water rights. So what is our answer for this one? It's going to be D. It is riparian rights. So under riparian rights, all landowners whose properties adjoin a river or stream have the right to make reasonable use of it as it flows through or over their properties. The only limitation owners have is they cannot stop or prevent the flow of water. Riparian rights vary from state to state, but most grant unrestricted use. Unrestricted use means owners have the right to access it for swimming, boating, fishing, building docks, etc. So that one's pretty straightforward. A little trick, if you guys haven't heard this before, if you're a fan of the channel, I'm sure you have, but a good way to remember riparian rights versus littoral rights is riparian stands for river. So when you think of riparian, think of river. Riparian, river. When you think of littoral, think of lake. And if we do get the littoral question, you'll see kind of why that makes sense for littoral. But again, when you hear riparian, think of rivers. And again, in this question, it said adjoin rivers. It basically gave us the answer, guys. It says river, rights, rivers. That's all you need to know. Rights, rivers, riparian. Boom. Boom, roasted. There you go. So it's as simple as that. All right, I apologize for the poor humor. All right, next one. All right, 27. All right, an appraiser has been hired to prepare an appraisal report of a property for loan purposes. The property is a 25-year-old strip mall. To which approach to value should the appraiser give the greatest weight when making this appraisal? It gives us 4 options. Is it the A, income approach, B, the gross rent approach, C, the sales comparison approach, or D, the property expense approach? So as always, I'm going to give you guys an opportunity here. Go ahead and think it over. Come with your answer. Alrighty, so what is the answer for this one? Well, it's going to be the income approach. The income approach. So the overall appraisal process is based on a number of factors, and appraisers usually use a combination of approaches, but they give weight to the most and the most important. So the income approach determines what a property generates in terms of income for its owner. So it's pretty straightforward there. And that also includes obviously potential for income, which is worth noting. But that is used to calculate or identify the market value of the property. The income approach is primarily used for rental properties, and in this case would be given the most weight in the appraisal process. And again, that makes sense, right? Because let's take a look at our question. It says, an appraiser has been hired to prepare an appraisal report for a 25-year-old strip mall. So when you're looking at a 25-year-old strip mall, you're going to be looking at its income. How much is it making? Things like that. That is going to have the greatest weight when making an appraisal. So pretty straightforward there. All right, next one, 28. So 28. Richard is renting property from Becky. Richard is on a month-to-month lease. This past month, he did not pay his rent. Richard's interest would be classified as, and it gives us 4 options: in a state at will, in a state at sufferance, in a state of periodic tenancy, or D, in a state for years. So, like usual, have some time here to figure out the answer, starting now. Alrighty, so Richard, what's going on with Richard? Let's figure that out. So for this one, we would be dealing with B, an estate at sufferance. Why? Well, a tenant who continues to occupy property after his or her rights have expired is said to be occupying the property under an estate at sufferance. And that makes sense, right? I mean, there's somebody suffering. When you hear a situation where the landlord is suffering because, again, the property is not making any money, that would be an estate at sufferance. It's a fun little way to remember that one. But yeah, pretty straightforward there. All right, next one, 29. All right, yeah, we just had Richard, now we got Steve. All right, so Steve, a real estate agent of 5 years, was at his local coffee shop with some agents from the other offices. The subject of commissions came up, and agents began to compare their commission rates. What should Steve do? So there's 4 options. A, excuse himself from the discussion, as this would constitute a violation of the Equal Credit Opportunity Act. B, excuse himself from the discussion, as this would constitute a violation of the Fair Housing Act. C, advise the other agents that this could constitute a violation of the Sherman Antitrust Act. Or D, listen carefully so he can be more competitive in the market. So let's come up with our answer on this one. Here's some time for you guys to figure it out, starting. Alrighty, so what is our answer for this one? Well, it's going to be C. It is advised the other agents this would constitute a violation of the Sherman Antitrust Act. So, a couple key takeaways. One, when we're talking about the Antitrust Act, technically it's called the Sherman Antitrust Act. Don't be confused by that. That's just its full name. Secondly, Steve should do this because, again, oh, and there my cat just left. Excuse that noise right there. But again, the Sherman Antitrust Act, he should be doing this. Okay, sorry, I lost my train of thought. When we're looking at this question, okay, what you want to do, this is super simple, is you want to look at the laws. You want to look at what they give. So they say Equal Credit Opportunity Act, the Fair Housing Act, and then the Antitrust Act. What is the act or law that basically goes with this question? That's what you should be doing when you're looking at these types of questions. And in this instance, we know it's an antitrust violation to discuss commissions, commission planning, things like that. Or price fixing is technically called. So price fixing is an antitrust violation. Because we know that, because we know this, we know that it is option C. Now, again, some of you guys might be thinking, oh, well, wouldn't it also be technically A, B, A or B or whatever it might be? That doesn't matter, guys. What matters the most is that you correlate the best answer, the best law given, with the best potential antitrust violation. Or, not even antitrust violation in all types of questions like this, but in this specifically, the antitrust violation. But for questions that are like this, just, again, take a step back, look at the laws that they provided, and then look at what information lines up with the law. And obviously price fixing, we know price fixing. We know that's a bad thing. We know that is prohibited by the Antitrust Act. So instantly we know it should be C. That's how your mind needs to be thinking on these questions. And simple as that. But yeah, so just a little footnote, real estate agents and brokers should understand that any discussion about commission could constitute a violation of the laws, even if only implied. So just remember that when you guys are out there working. All right, question 30. A property owner enters into a listing agreement with an agent. The seller obtains a buyer for the house, but the agent receives a commission. The listing agreement between the agent and the property owner was probably, and it gives us 4 options. Is it A, an open listing, B, a closed listing, C, an exclusive agency listing, or D, an exclusive right to sell listing? So come up with your answer on this one, and here's some time to figure it out. Alrighty, so we should know the answer to this one, guys, when we talk about our listing agreements, and that is going to be D. It is an exclusive right to sell listing. So this is when the agent gets paid no matter what, regardless of whether it's the agent or the seller. Knowing this, it's safe to assume this was an exclusive right to sell listing. So again, remember, guys, someone's getting paid here. Someone's getting paid. Paid no matter what, you should know that means exclusive right to sell. So simple as that. Alrighty, next one, 31. This approach determines what the property generates in profit for its owner or potential owner. Is it A, the cost approach, B, the income approach, C, the gross rent multiplier, or D, the sales comparison approach? So come up with your answer on this one, starting now. All right, if you need more time on this one, feel free to pause here, but we should know this one, because if you guys were paying attention, you'll remember that we discussed this earlier. So what is our correct answer for this one? It's going to be the income approach. That's right, is the income approach. And why is that? Well, it pretty much gives it in the definition here. The income approach determines how much a property generates, income for its owner, that income, or potential for income. And again, this is used to calculate or identify the market value of the property. And again, the property or the income approach is primarily used for rental properties, as not all properties normally generate income. Makes sense, right? Right. All right, next one, 32. All right, an interest in real property which is held for the duration of a life or of the life of a designated person is called what? So it's A, life estate, B, fee simple absolute, C, fee simple defeasible, or D, estate at will. So like always, here's some time for you guys to figure it out, starting now. All right, so this one's pretty easy. Again, remember earlier I was talking about don't overthink these problems. When we're talking about life, or we're talking about designated person for life, we're talking about the life estate. So a life estate is an interest in real property which is held for the duration of the life of a designated person. It may be limited by the life of a person holding it or by the life of another person, but that designated person is called a life tenant. So again, don't overthink these ones. It practically gives us the definition in the problem. So just remember your definition, remember your flashcards or however you study your vocab words, however that may be, and just know, oh, yep, it's a life estate. Simple as that. All right, 33. There are three main forms of depreciation. What are they? Choose the best answer here. So, all right, so there's four options. A, major obsolescence, minor obsolescence, and physical deterioration. B, seasonal obsolescence, quarterly obsolescence, and yearly obsolescence. C, seasonal obsolescence, economic obsolescence, and physical deterioration. Or D, economic obsolescence, functional obsolescence, and physical deterioration. So out of all these answers, what are the three main forms of depreciation? So give some time to think that one over and come up with your answer. Alrighty, so what is our answer for this one? Well, it's going to be our last option. It's going to be D. Economic obsolescence, functional obsolescence, and physical deterioration. Those are the three main forms of depreciation, and I'll leave that one as that because I'm sure the definitions of these, or they're going to come up a little later. So, all right, so 34. Which situation is legal under the Federal Fair Housing Act of 1968? All right, so A, the instance of a widowed woman on renting her spare bedroom only to another widowed woman. B, the intentional neglect of withholding certain property to your clients to buy for yourself. C, the refusal of the property manager to rent an apartment to a Catholic couple who are otherwise qualified. Or D, the ability to buy a property with the intent to resell it to your mother-in-law for double the price. So think this one over. This one well, I won't say anything other than that. Just think this one over. Here's some time for you guys, starting now. Alrighty, so what is the correct answer for this one? The correct answer is A, The instance of a widowed woman on renting her spare bedroom only to another widowed woman. Okay, let's break this problem down because I get hundreds of questions, comments, all that stuff about this problem. So first and foremost, I'm going to read the explanation and then I'll give you guys some additional thoughts and stuff like that. So the Federal Fair Housing Act is a law that prohibits discrimination, buying, selling, renting. We all know that. These laws discriminate based on race, religion, color, sex, disabilities, children, nationality, and more. Okay, you cannot have a listing that states looking for white people only or looking for married couples with children only. The interesting thing, though, is you can put language referring to sex. For example, seeking female roommate. However, it's only in cases of finding someone to share living spaces with. That's super important to take away. And the only way that you really know this is one of two ways. One, you read the entire Federal Fair Housing Act and you figured it out. Or B, someone told you this and from henceforth you've kind of understood it, that that's just the way it works. And in most cases, it's going to be B. I mean, let's be honest. Have you read the entire act? Probably not. Most people, they just know, okay, this is one of those exceptions that they have to be aware of for the exam. The other thing I'm going to just talk about with this question is, again, it's saying which situation is legal under the Federal Fair Housing Act. So for starters, that means when you hear a question like that, you have to understand you have to throw everything out, because the chances are there's going to be an answer that may be legal as well, but is not legal under the Federal Fair Housing Act. So for example, let's look at this option D right here. It says the ability to buy a property with the intent to resell it to your mother-in-law for double the price. Guys, that's legal. That's completely legal. You can do that. It's not right. It's probably a little mean, but that's perfectly legal. But it's not specified under the Federal Fair Housing Act of 1968. Nowhere in that act does it discuss, selling properties to your mother-in-laws for double the price because you don't like them. Nowhere does it discuss that. And that's what you have to understand with these questions. And that's why I think I swear I get so many questions about this question or this type of question, is you need to read the full question. It says, which situation is legal under the Federal Fair Housing Act of 1968? It doesn't say which situation is legal. It doesn't. Because if that was the case, then we'd have, conflicting answers. And then it would be, we'd be like, oh crap, we got two questions that technically could be correct, excuse me. But in this instance, again, we have to look at which situation is legal under the Federal Fair Housing Act of 1968. We have to look at that specified law. And when we're looking at the specified law, we know for a fact, and again, how I discussed earlier, either one or two ways. One, you learned it, which is probably true, or two, you read the specified law and you understood the exceptions to these laws. Chances are somebody told you. Chances are you learned it maybe in your pre-licensing course. Chances are maybe you're learning it now. But the instance of a widowed woman on renting her spare bedroom only to another widowed woman is perfectly legal. Because again, that is an exception, and it is, language referring to sex. There are exceptions included in that. So hopefully that makes sense. Hopefully I cleared that thing up. If you do have any questions on that, I'd be happy to explain down below. But again, don't overthink these questions. Just my advice is just read the full sentence, really understand the whole question it's asking, and then come up with your best answer there. All right, next, 35. Which of the following best describes real property? So it gives us four options. Is it A, all things attached to land and the legal rights to it? B, all things removable, like clothes, lawnmowers, couches, TVs, and furniture? Or C, all trees or bushes connected to land? Or D, I'm sorry, there's a D, bonds or intellectual property. So, like usual, come with your answer. Here's some time for you guys to figure it out. All right, so I'm going to quickly go through this one. This one should be pretty self-explanatory. What is real property, guys? You should be familiar with this term. It's all things attached to the land and the legal rights to it. So remember earlier we were discussing personal property. Now we're talking about real property. Real property is all things attached to the land and the legal rights to it. Real property is usually things immovable, such as the home itself or the buildings within the property line. Now there are some exceptions of items that can be moved but are still real property, like for businesses or business related items like mineral rights, or if you own a farming business, remember earlier guys, that would include crops, barns, stables. Those are considered real property because it's part of the business. And don't get that confused with emblems, which are personal property, because remember, that's specifically with a tenant. But again, business-related items, that's a general statement. So if you own any, mineral rights, if it's like an oil company, or if it is a farming company, it would be like the barn or the stable. Again, that would be real property because it is attached to the land and is the legal rights to it. All right, next one. 36. When you buy real property, you gain several different kinds of rights, one of which are rights called subsurface rights. What are subsurface rights? So here's some time for you guys to think that one over, starting now. All right, so I won't give you too much time on that one because we did go over surface rights earlier, so you should be familiar with subsurface rights. So what is our correct answer? What are subsurface rights? That is going to be A. It is the rights to the natural resources lying below the Earth's surface. So again, surface rights, what we discussed earlier, are the rights to use the rights of the surface of the Earth. Subsurface rights are the rights to the natural resources lying below their surface. Interestingly, an owner, as we discussed earlier, may transfer rights to subsurface without transferring the surface rights, and vice versa. So, simple as that. All right, next one, 37. The Latin phrase ad valorem comes up often when talking about property taxes. What does ad valorem mean? All right, and there's four options. Is it A, value, B, added value, C, according to value, or D, property value derived from asset value? So, like usual, here's some time for you guys to come up with your answer. Alrighty, guys. Have you touched up on your Latin? Hopefully. So, what is the answer for this one? Well, it's going to be according to value. C as our that is our option. That is our answer. The term ad valorem is Latin for according to value, which means that it is flexible and depends on the assessed value of an asset, product, or service. So an ad valorem tax, what does it mean for us? Well, that ad valorem tax is charged by state and municipal governments and is based on the assessed value of a product or property. The most common ad valorem tax is property tax, which is charged on real estate and personal property. So pretty simple, guys. Just be familiar with this one Latin phrase. Actually, there's a couple Latin phrases that you need to be familiar with for the exam, but this one especially, just because it does have to do with property taxes, and they love to ask you about property taxes. Not just the property tax problems, but also just the definitions and the specific vocabulary terms associated with taxes and things like that, which again, here we are, ad valorem. So just be familiar with that term if you're not already. Yeah. All right, so 38. All right, the deed that offers the grantee the most protection. With this type of deed, the grantor makes a series of legally binding promises called covenants and warranties to the grantee, agreeing to protect the grantee against any prior claims and demands of all persons whomsoever in regards to the conveyed land. So it gives us four options. Is it A, the general warranty deed, B, the special warranty deed, C, a quitclaim deed, or D, a trustee deed? So here's some time for you guys to think this one over, read it over, all the good stuff starting now. Alrighty, so what's the answer for this one? Well, it's going to be the general warranty deed. It's A. A is our correct answer. So, when you are looking at these deeds, or deed, the general warranty deed offers the grantee the most protection. The general warranty deed protects homeowners from stakes and claims from previous people from now to all the beginning of time. It also protects homeowners from any potential encumbrances. A general warranty deed grants an undeniable fact that this property is coming with no liens, no heirs that could potentially lay claim to the piece of property. So what's so important about this one? Well, guys, when you are dealing with deeds and the different types, chances are you're going to be dealing with the general warranty deed. That is the most common. You're going to see that the most often. And again, that is the greatest. It is the best. It demands the most protection. You want the general warranty deed. It's like the cream of the crop, as they say. But yeah, pretty self-explanatory there. When you're just looking at this question, just make sure to dissect it. Obviously it says the deed that offers the grantee the most protection. Don't overthink this. If you know your deeds, you're going to know this problem. It's as simple as that. If you didn't know it, then you need to study up on your deeds. Stuff like that. Simple as that. Things you should be thinking about while we're doing this. All right, 39. Which of the following is not a type of depreciation used in the cost approach? Is it A, functional obsolescence, B, physical deterioration, C, economic obsolescence, or D, intangible deterioration? So, like always, here's some time for you guys to figure it out, starting now. All right, what is our answer for this one? What is it going to be? It's going to be D, intangible deterioration. Why is that? Well, there's no such thing as intangible deterioration. Remember, guys, earlier we discussed the three types. We had functional obsolescence, physical deterioration, and economic obsolescence. D's are answer because there's no such thing. And when they're doing the cost approach, they are factoring in A, B, and C. So keep that in mind. But yeah, tangible deterioration, no such thing. We know that that is the answer because it doesn't exist. All right, 40. Closing is always the blank step in executing a real estate transaction. Is it A, second, B, third, C, fourth, or D, final? So come up with your answer. Here's some time for you guys to think about it. All right, pretty easy one. Just going to get into it. It is the final step, guys. It's the final step. Closing, obviously, is known by many names. Passing paper, settlement, transfer, all that good stuff. Traditionally, obviously, it's called closing. But no matter where it is, no matter what state you live in, it is always the final step in executing a real estate transaction. And that's super important to know. Because when we're dissecting the real estate transaction and we're looking at it kind of, like a map or even, a math problem, I guess that would be a better example. We have A, B, and C. We have our, the beginning of the problem, the end of the problem, and then the final, your final answer. Closing is that final answer. That's the final part of the problem. It's the final step in executing a real estate transaction. So simple as that. Hopefully you guys are understanding that. All right. So 41, if a buyer refuses to go ahead with a purchase of property, which he has signed a contract, what usually happens to the earnest deposit or the earnest money? So there's four options here. A, it is kept by the seller. B, it is kept by the buyer. C, it is kept by the escrow company. Or D, it is split between the escrow company and the seller. So go ahead and come up with your answer on this one. Alrighty, so what is our answer on this one? Well, it is going to be A. It is kept by the seller. So why? Well, the seller is usually entitled to keep the earnest money because this is considered forfeiture of the contract. The only way the buyer can back out and get their earnest money back is if something happens with the inspection, appraisal, or they have a contract clause offering that protection. Guess what, guys? It doesn't mention any of that in this problem. It just says a buyer refuses to go ahead with a purchase of property which he has signed a contract for. What usually happens to the earnest money? So usually in this instance, again, without the contract clause, without the inspections, appraisals, stuff like that, it is going to be kept by the seller. It's as simple as that. Alrighty. All right. So question 42. Which of the following situations would a percentage lease be most commonly used in? Is it A, apartments, B, townhouses, C, shopping centers, or D, government owned properties? So go ahead and think about this one and come up with your answer starting now. All right, so when we're discussing percentage leases, what are we talking about? What are we thinking about? What property? What situations? Well, that's going to be C, shopping centers. So a percentage lease pertains to commercial real estate. That's what we need to think about. We need to think about commercial real estate when we're looking at percentage leases. A percentage lease is a rental that is based on a percentage of the monthly or annual gross sales made on the premises. So percentage leases are commonly used in large retail stores, especially shopping centers. That's where we get our answers on this one. So don't overthink this one. When I know we're talking about leases. Sometimes people can get a little bit confused, but again, percentage lease, keep it simple. We're dealing with shopping centers. We're dealing with commercial property. It's all one and the same. All right, next one, 43. All right, a property owner enters into a listing agreement with an agent. Another agent obtains a buyer for the house, and the first agent does not receive a commission. The listing agreement between the first agent and the property owner was probably, and it gives us four options: A, an open listing, B, a closed listing, C, an exclusive agency listing, or D, an exclusive right to sell listing. So I'm going to go ahead and give you guys some time to figure that one out, starting. Alrighty, guys, what's our answer for this one? Well, it's going to be A. It's an open listing. Why? Well, open listing, guys, they're truly open. Sellers might consider an open listing if there are a lot of buyers in the marketplace. An open listing is when an agent or broker can participate in the listing and is entitled to commission if he or she produces a sale. Since the listing agreement between the first agent wasn't met, it had to be an open listing because another agent obtained a buyer. So really the proof is in the pudding, as they say. If you look at this question, it says here a property owner enters into a listing agreement with an agent. Okay. Another agent obtains a buyer for the house. Oh, red flag number one. And then red flag number two, the first agent does not receive a commission. Okay, knowing that information, knowing those two red flags, we know that it's an open listing because, again, open listings are truly open. So, yeah, it's as simple as that. All right, so 44. All right, so what type of ownership model is used for vacation real estate in which multiple purchasers own allotments of usage, typically in 1 week increments for the same property? Is it A, a condo, B, a timeshare, C, condominium, or D, an ownership in severalty? So go ahead and come up with your answer on this one starting now. All right, so this one's pretty straightforward, pretty easy one. What is the answer? It's going to be B. It's a timeshare, right? Right. So a timeshare is a property with a divided form of ownership or use rights. These properties are typically resort building units in which multiple parties hold rights to use the property. Each owner of the same accommodation is allotted their period of time. They differ from regular condominiums as they typically are exclusively for vacations. So pretty self-explanatory, understanding, easy one there. Alrighty. Ooh, here's a fun one. Awesome. So question 45. All right, an example of an antitrust violation. Uh-oh, we talked about this earlier, remember guys? All right, so it gives us four options. A, selling more than 100 houses in a taxable year. B, buying a house in another state. C, an equity loan. Or D, price fixing. So go ahead and take some time, figure it out, come up with what you think is an example of an antitrust violation. Alrighty, so we already kind of actually talked about this earlier. If you guys have been paying attention, we talked about price fixing. Remember that? We gave some examples, and that is our correct answer for this one. So, fixing or price fixing is the practice of setting the price of a good or service to make a particular price a standard. So, in our terms, real estate fixing is when competing agents meet up and agree on the same commission rates. Typically, agencies set their commission rates depending on the price of the property. Any agreement, even if it is just implied with another brokerage, to set a standard commission rate is a violation of the antitrust laws. So again, we discussed this earlier. Remember, we gave that coffee shop example. The guy came in. What was his name? Steve or Richard? I can't remember. Let's just say Steve. Remember, Steve went in there and he heard his buddies were talking about commissions from their other agencies. Remember, he cannot discuss that. He needs to leave because any talk, even if implied, to set even discussion of these commission rates from other brokerages, that is a violation of an antitrust law, and it can be, and probably would be if they looked into it, considered price fixing. So yeah, keep that one in mind. Hopefully you understand that. Alrighty, let's see. Question 46. Mrs. Thompson hired a broker to find her a 100 plus unit apartment complex for sale. Upon finding one she liked, she made an offer for $2.5 million to include all the personal property as well. In order to include all the personal property, Mrs. Thompson needs A/An, and it gives us four options. Is it A, an investment unit loan, B, an amortized loan, C, a package loan, or D, a balloon loan? So, gonna give you guys some time for this one. Think of the correct answer, hopefully come up with it, and I'll be right back in a couple moments. Alrighty, so what is our answer on this one? What is Mrs. Thompson getting into? What is she dealing with today? All right, so our correct answer for this one is going to be C. It is a package loan. So, since the offer includes all personal property as well, that's super important to distinguish, Mrs. Thompson is required to do a package loan. A package loan is a real estate loan used to finance the purchase of both real property and personal property, such as the purchase of a fully furnished condominium. So that's what Mrs. Thompson was dealing with in this situation. She wanted both personal and real property, which means it was a package loan. That's the only way they can do that, is when they have both the real and personal property. That would be a package loan. Alrighty, so I always, not to get sidetracked, but I always really get interested in the concept of package loan, because it makes you wonder how far, how much personal property could somebody go? Could they throw in their motorhome? Could they throw in, a bunch of golf equipment or something like that? I don't know, just, real estate nerd thoughts. All right, 47. All right, In the appraisal of a building constructed in the 1930s, the cost approach would be the least accurate method because of difficulties in, and it gives us four options. A, estimating depreciation. B, estimating changes in price of building materials. C, estimating changes in the cost of construction. Or D, estimating depreciation, estimating changes in cost of construction, and estimating changes in prices of building materials. So that's pretty much like D is like all of the above. All right, so yeah, here's some time for you guys to come up with your answer on this one. Alrighty, so what's our answer for this one? Well, it's definitely going to be D. Yeah, so it's going to be all of these examples here, guys. The cost approach is considered to be super reliable, but that's when it's used on newer buildings, and not reliable with older ones. And why is that? Well, let's be honest, guys. After a certain amount of time, it's going to be really difficult to do all of those things listed. Again, depreciation, changes cost of construction, changes in prices of building materials. That's why the cost approach becomes nearly ineffective after 25 years or so, because it's so difficult to calculate all of those things. But yeah, so hopefully you guys understood that one. Let's move on. All right, 48. A legal way to dissolve the relationship when the parties don't voluntarily agree to its termination is called what? It gives us four options: disbursement, divorce, partition, or parceling out. So A, disbursement, B, divorce, C, partition, or D, parceling out. So come up with your answer on that one. Here's some time for you guys. Alrighty, so what is our answer for this one? Well, it's going to be C, partition. This is one of those legal vocab words that you need to be familiar with. Partition is a term used in real estate to describe an act by court order to divide up a concurrent estate into separate portions representing interest of the owners of a property. So again, it's just one of those ones. Another reason why it's so important that you know your vocabulary. It's so important because they love to ask you about questions that, you know, specific terms. And even if they don't ask you about that specific term, then they'll ask you a question with that term, and you gotta hope that you're familiar with the term, or else you won't even understand what they're asking. So yeah, just be familiar with your legal terms, especially the ones that have to deal with contracts and dissolving contracts. Yeah. All right, next one, 49. All right, one individual or married couple in business alone, the most common form of business structure. Okay, is it A, sole proprietorship, B, limited partnership, C, single corporation, or D, an LLC, or a limited liability company? So, going to give you guys some time to figure that one out, starting. Alrighty, so are you guys familiar with their business structures? Hopefully, because they do show up on the exam, and you need to be familiar with how they operate for a couple different reasons, but primarily to understand how they own property. But I'll get into that later. So, what is our correct answer for this one? What is one individual or married couple in business alone? That's going to be a sole proprietorship. So, a sole proprietorship is one individual or married couple in business alone. Sole proprietorships are the most common form of business structure. This type of business is simple to form and operate and may enjoy greater flexibility management, fewer legal fees, and fewer taxes. However, the business owner is personally liable for all debts incurred by the business. A sole proprietor may purchase property for both personal and business use through his name or through the name of the business. I'm going to read that one more time because it's so important. A sole proprietor may purchase property for both personal and business use through his or her name or through the name of his business. So, what does that mean? Well, again, when we're discussing these business terms or these business structures, you need to understand how the business structure owns property. That is the biggest thing. That's why you need to understand these. It's as simple as that. You need to understand business structures just for that reason. And obviously, the other reasons are good and important as well, especially when you go out in the business world. You're going to need to know these things, but that's the primary reason, is so that you understand how a business owns property, what are the legal rights included, who owns what, and things like that. And again, when we're talking about a single proprietorship, they can own it personally or through their business, either or. When we get into corporations, they can't do it personally. It's only through the business. It's only through the corporation. Hopefully that makes sense. And it will later if you stay tuned for the entire thing, because I'm pretty sure there's a couple more of these questions, business-related questions coming up. And if not, we do have videos on that as well, but I digress. All right, next one, 50. All right, a homeowner hired a construction company to build a swimming pool at his home. The homeowner failed to pay the bill once the work was completed, and the construction company filed a lien to obtain payment of the debt. The encumbrance created is called what? So is it A, a luxury expense lien, B, a property tax lien, C, a mechanics lien, or D, a voluntary lien? So I'm going to give you guys some time to figure this one out, starting now. Alrighty, so what is our answer for question 50? Well, it's going to be C, a mechanics lien. Why? Well, mechanics liens are legal documents that essentially reserve the rights of the filer to seek unpaid compensation. So it doesn't have to be a mechanic specifically. It could be anyone who, did something and they weren't paid compensation. So again, it's to seek unpaid compensation. They're usually filed by contractors, subcontractors, or suppliers that never received payment for work they performed or materials that they provided on the property. And again, that's what's coming up, because if we dissect this problem, it says here a homeowner hired a construction company, but they did not pay the bill. It says right there, they failed to pay the bill. So because they failed to pay the bill, a mechanic or a contractor, subcontractor, something like that, they can file a mechanics lien so that they can get their unpaid compensation. Understand? Hopefully. But yeah, that's a pretty fun one. But yeah, so we just did 50 questions. Wow. Whew. That's going to be it for part 1 of our practice exam. Hopefully you guys enjoyed. Hopefully I made it a little fun. I know this stuff is kind of tricky to make exciting. Obviously we had a couple distractions. My cat in the background. Shout out to my cat. Shout out to my bad humor, all that good stuff. But no, seriously. Hopefully you guys enjoyed. Stay tuned for part 2. And don't forget, if you want to study at your own pace, check out our website, realestatelicencewizard.com. There you can take our practice exam, plus check out lots of other study tools. But yeah, I hope you guys have a fantastic day. As always, this is Zach from realestatelicencewizard.com. As always, guys, make today magical. I'll see you guys next time.